Right, seem to be up and running again. Again, apologies for that. Right, so I was just saying, my name is Mark Gracie. I run the Digital Compliance Hub. I also act as a consultant specialising in looking at data protection, privacy and marketing compliance and data security as well. I'll tell you a bit more about Digital Compliance Hub towards the end. But today's session is going to be about the privacy regulations, what they look like right now, because we have ePrivacy regulations, and you may have heard when there was all the panic and the hysteria around GDPR and what that might mean, particularly around consent and to do with marketing, that there is another regulation called the Privacy Electronic Communication Regulations. And so I'm going to sort of talk through that and explain what that means to marketing, with a particular focus on digital marketing. And then, as I say, we'll pick questions up at the end. So the Privacy and Electronic Communication Regulations, or PECR, as they tend to be abbreviated to, are a set of regulations that came into force in 2003. They've been amended over the years. In fact, you may have seen in the media over the weekend that they've just been updated in a sort of small way, but quite a significant way, to allow the Information Commissioner to control and regulate better, or more to the point, prosecute PIP and sort of the you've been in an accident kind of cold calling, and there was a regulatory change that was announced by the government, I think back in May, to allow a better sort of prosecution of those kind of services. But the Privacy and Electronic Communications regulations have been around, as I say, since 2003, and that those four key things there, the two light blue and the two dark blue, are the key areas that it covers. So it covers what you can and can't do when it comes to digital marketing and consent, and the linking with GDPR, we'll talk about in a second, is related to that. It also sets out the rules around cookies and other similar technologies that you might be using on your website. And it also covers off a few other things, particularly aimed at telecommunications providers. So the reason the two light blue ones are light blue is I'm not going to talk about those aspects of PECR. I'm going to focus on the two dark blue, so the digital marketing and the cookie rules. The two light blue ones relate specifically to network providers, and they basically say they have to provide secure communication technologies and also enforce privacy. And actually, if you're a telecommunications provider, you'll also be familiar with PECR on the basis that that actually sets out some requirements relating to the notification to the Information Commissioner's Office about breaches. So even though GDPR has breach elements, and that was the focus of the webinar I ran last month, which applies to everybody, PECR actually has specific obligations if you're a telecommunications operator. But that's not going to be the focus of today's talk. I'm going to focus briefly on cookies, but mainly and primarily on digital marketing and what that means. Now, when it comes to digital marketing, as I've already mentioned, there's the element of general data protection regulation, and I guess you're familiar with GDPR and that coming into force on the 25th of May this year, and the changes to the consent rules. And the digital marketing and the cookies both make reference to consent and what you can and can't do, and what consents you do and don't require. And they tie into what data protection law says about consent. So where consent is referenced in the Privacy Electronic Communication Regulations, that is GDPR consent. So that means, in essence, that if you are required to have consent, and I'll talk about what those consents might look like in a moment with regards to the PECR regulations. But just to recap on GDPR and what it says about consent, because this was one of the significant things that changed, and I suspect that just like me, you were bombarded by lots of people asking you to re-seek consent, and particularly in the lead up to the end of May when the GDPR came in. But GDPR has very specific controls in place now, that if consent is the lawful basis for processing, so this only applies where consent applies, and that's your lawful basis for processing, you have to make sure that you are very clear and open and transparent about what that consent is needed for and why you're asking for it, and you have to get a positive opt-in. So the individual has to take an affirmative action. So if you need consent, somebody must be able to know why you're asking for consent, and they have to give you an affirmative action to give that to you. So that's put the end to, in a lot of scenarios, the end to pre-ticked boxes. And it means we can't use tricky wording that's a bit confusing. You're not sure whether you're supposed to tick a box or not tick a box, or go off to some very small print and not actually find what it is that you're supposed to be consenting to. So clear messaging, positive opt-in. You can't force somebody to give you consent, which is the point there about consent without detriment. You have to record. So sorry, what I mean about that, you can't say that consent is, you can have this service, but you will therefore consent to these things. That's not allowed. The proof of consent point is that you have to be able to demonstrate, because of the accountability principle in GDPR, that you have been given that consent. So you would have to be able to say, well, here's the message that was given. This is the action that somebody would have had to have taken to give us that consent. And we can tell you that this happened on this particular in this particular way, or in this particular date and time. And if you're using electronic marketing and using something like MailChimp or other kinds of email marketing tools, then you will have a record, because they tend to record when somebody gets added to your mailing list and so on. And then there's the tricky point about consent, which is why it's not always as good as it sounds, but everybody has an absolute right to withdraw their consent. So it doesn't matter whether they change their mind 2 seconds later or 2 years later. If somebody says they no longer want to give you that consent, then they have a right to withdraw that, and it's your requirement. You are required, and you will have to be able to demonstrate that you've taken appropriate action to recognize that withdrawal of consent, and if necessary, take whatever precautions you need to make sure that whatever they've consented to doesn't continue. So consent is very much a binary question. Do you consent to us doing this with your data? Yes or no? And everybody has an option to say no, and also they have the option to have said yes in the past and now change their mind and opt out. So consent plays a very good and important role within the privacy regulations and what that might mean. And the GDPR has updated those consent rules to be very, very specific. And we'll talk about what that means next, about the privacy electronic communication regulations, where GDPR consent fits into that, and where that specifically is aimed at the kind of marketing you might be doing. So, as I said, PECR is much wider than just about marketing and marketing consent, but when it comes to marketing, it sets out a set of rules around what you can and can't do. So what's lawful and what's not lawful processing of marketing data for the purposes of privacy and digital marketing, where it doesn't clearly define what those terms are in terms of what electronic marketing might mean, but which, from a regulator's point of view, that's quite good, because it means they're able to sort of attach different types of messaging and things as time goes by. But from a marketing point of view, electronic marketing typically means phone marketing, text marketing, so that's using SMS on mobile devices, email marketing, which is what most people think about as when they talk about electronic marketing. And actually any kind of electronic messaging. So if you're sending social media messages and they are marketing messages, then strictly speaking, they're covered by PECR right now, rather than something that might be coming in the future. And I've grayed it out in light blue because I don't know how many people are still using faxes. I still see fax numbers appearing in people's email signatures and things like that. So I know they're still out there, but I'm not going to be talking about fax messaging. But fax messaging and sending unsolicited faxes or marketing via fax machine was something that people used to do, businesses used to do in the past, and is therefore covered by this regulation. But I very much suspect that fax marketing is probably close to zero these days, if not very, very small amounts, which is why I'm not going to focus on that, which is why it's sort of grayed out or light blue on that diagram. So when it comes to phone calls and using the phone to do your marketing, so telemarketing essentially, there's the regulation addresses this from two angles. There's the live call, so that's somebody ringing you up in person and having that conversation. And I'm sure you've all got your own horror stories about the kind of calls that you might get, be they the personal insurance protection, the PIP stuff, or be they people trying to convince you that your computer's not working anymore or your internet's gone down, those kind of things. But strictly speaking, if you're talking to a live person, they should have only rung you if you've given consent to that that kind of marketing, or if they don't have consent from you, that they've checked that you're not registered with TPS or CTPS. Now, TPS is the telephone preference service, and the CTPS is the corporate version, so the C is corporate. So the telephone preference services are basically a way for, so TPS is for individuals, so us as private citizens can go to telephone preference service website. I think it's run by the Direct Marketing Association, the DMA, and you can register your telephone number and say you don't want to receive telephone marketing. And telephone marketers are supposed to either have consent to call you or have checked that you're not registered with the TPS. If you are registered with the TPS, then they shouldn't be calling you. If you're a business, you can register with the corporate telephone preference service, and the same rules apply. Essentially, that you either got consent, or if they haven't got your consent to call you, and they shouldn't be calling you if you've registered your business on the corporate telephone preference service. Now, it's free to register on those services, but you do need a license if you're on the other side. So if you're doing telephone marketing, you will need to have a license to get access to the telephone preference service to do the cleaning of the calls, the telephone numbers, before you make your calls. So that's when you're talking essentially face-to-face or voice-to-voice, so live calls. If you're using automated telephone systems, so these auto dialers that send you these messages that are pre-recorded, you must have consent. There is no choice. You can't do it even if somebody is not listed on telephone preference service. If you're using automated telephone marketing systems, you must have consent to do that. And just to reiterate what I was saying before, for the purposes of what that consent needs to look like, that needs to meet the requirements of what we were saying about GDPR consent. So everything here. So if you need consent when it comes to privacy electronic communication regulations, then it needs to be GDPR compliant consent. Now, when it comes to email marketing, which is probably typically where most people are going to be interested, where this also extends to text-based marketing and other forms of messaging and using marketing, things like social media, for example, then there is a difference depending on whether you're dealing with what I'll refer to as consumers or private individuals and businesses. So we'll look at both of those scenarios, but essentially, let's deal with consumers first. So if you don't have any kind of business relationship with an individual consumer, then you can't market to them unless they've given you consent. And again, that needs to be GDPR compliant consent. So that means that you can't scrape a load of email addresses off of profiles on Twitter or something like that, and then email them if they're consumers, because you would have not had a business contact with them at that point, and therefore you would need consent. So inbound marketing tools and approaches to get people to come to you, to land on your website, get engagement with you, is the kind of way that you'll probably be thinking about doing your marketing, because unless you have consent for people to contact you, so that means somebody's gone to your website, said, yes, I want to hear about your marketing material, and signed up to your mailing list, that kind of thing, then you can't market to them without that consent, and that needs to be GDPR compliant consent. If you're looking at buying in third-party lists, so people who might sell you a list of consumers who are interested in hearing about your products, then you can market to those individuals, but you will need to, as required by the General Data Protection Regulations, this isn't necessarily a PECR per se, but the GDPR does require that if you need to basically make sure that you've got the appropriate consents to do that. So if a third party says they've got a list of 10,000 consumers that are interested in hearing about businesses like yours, then you will need to carry out due diligence on that provider of that list to make sure that they can demonstrate to you that they had the appropriate consent. So people have opted in, and that opting in process meets the GDPR consent requirements. So don't think you can get around it by just buying in lists of email address, because you need to do a bit of background work to basically vet the list and the quality of the data, and make sure the people you're contacting have given their consent. And ideally, you'd want to make sure that they were clear that they were going to be contacted by organisations like yours, either because it's a very industry-led mailing list or a sector-led list, or that they've named you specifically. So if you've got a company out there that's trying to glean contact information for you, then people must ideally be able to say, yes, I am consenting to ABC Limited contacting me, for example. And then, of course, don't forget also under GDPR, this isn't a GDPR session, but GDPR obviously figures highly in this, just to mention that the GDPR would also require you, because of the right to be informed, that you must tell those individuals that that you have their data, and that you will be, this is the first of a number of marketing messages you'll be sending them, how you got the information, why you're processing it, and so on, and make it clear how people can opt out of that. Now, if you are in a business relationship with them, so you're dealing with customers, for example, then you can rely on what is called soft opt-in. And there was a lot of misunderstanding around the fact that GDPR got rid of soft opt-in because of that consent change. But actually, soft opt-in is the concept that basically, if somebody has bought a product or a service, or is in the process of doing that, then there's a good chance that they're interested in hearing about similar marketing. Or similar products and services. So what that law says, or what PECR says, is that provided the individual was given the opportunity to say they didn't want your marketing in the first place, then and they are therefore forever in the future given the opportunity to opt out at every communication that you send, then you can market to them, and you could claim that you have a legitimate interest, again another GDPR term relating to another lawful basis for processing. You have a legitimate interest to contact your customers about other products and services they might be interested in. So what this means in practice is that at the point at which somebody becomes a customer, you should really be saying, we would like to market to you, and select which way you want to be marketed, if you want to choose between phone, fax, text, email, whatever. But you should be asking that question. Interestingly enough, that it also means you don't have to go down the specific consent rules. So you can have a pre-tick box. So you could, in theory, say, we are going to market to you unless you untick this box. And whilst that doesn't meet the consent requirements, the soft opt-in does allow you to be a bit more flexible with that. That said, I think, and I've certainly seen this a lot with people who have misunderstood what the consent rules mean under PECR, and also where GDPR comes into this, that there is a general misconception that that's no longer needed anymore. And I've certainly seen businesses being accused of breaking the law because they are using the soft opt-in approach, i.e. you're opted in unless you tick this box to opt out. So you might want to look at that from a sort of a brand awareness and general perception of your brand and your business, as to whether you go down the route of saying, actually, tick the bits that you're interested in and let's get that communication going, rather than saying we pre-selected what we think you're interested in and deselect if you're not interested. So you might want to, and I've certainly seen that in both sides of that approach being used. And I think from a consumer's point of view, I think personally I quite like the option of saying, actually, do you know what, I'll opt into this, rather than being expected to understand some texts to decide whether it is something I do want or I don't want. So just to recap, if you're dealing with consumers, if you don't have any big kind of business relationship with them, you must get consent before you can market to them electronically. If you are in a business relationship with them, then provided they've given you the opportunity, you've given them the opportunity to opt out of your marketing when they became a customer, or in any ongoing marketing communication, then you can market to them, and you don't necessarily need to worry too much about the GDPR consent requirements. However, as I said, the problem with consent is that, or one of the problems with consent is that everybody has the right to opt out, and you will need to opt out. Need to facilitate the opt-out process, and the law requires that it should be as easy to opt out as it was to opt in. So that's why you need to make sure you have unsubscribe links in the bottom of emails. or you have facilities within your organization to cope with people ringing up or contacting you and saying, I don't want to receive these messages anymore, and make sure that you have a process in place to deal with those opt-outs. Because if somebody has opted out, that's it. You can't find a way round trying to avoid the fact that they've opted out. So, if somebody has opted out of the marketing, they've opted out of your marketing, you can't add them at a future date. And that means it is lawful for you to maintain a list of people who have opted out for the purposes of making sure you don't accidentally opt them back in again or send them marketing material in the future. And there is plenty of examples of where businesses have been caught out by that, by trying to manipulate wording and telling people that service change or change in terms and conditions. Oh, and by the way, we notice you're not opted in anymore. You should opt in because you'll benefit from these kind of things. That as a sort of a side message of an important message is marketing, and therefore there are examples of companies who have been fined tens of thousands of pounds for trying to manipulate people into opting back in when they clearly opted out. So consumers must have consent if you don't have a business relationship with them, but you can rely on soft opt-in if they're a customer or you've got some kind of relationship going with them. But everybody has to opt out. Now, when it comes to businesses, and again, there's a lot of confusion about this, and I've seen lots of people thinking that businesses have got it all horribly wrong. It's actually a bit more easier in some ways. In other ways, it's there's a bit of further understanding that you need to consider. So, first important point: if you're dealing with sole traders, and in fact some certain kinds of unincorporated partnerships, so for example, farmers tend to work as a cooperative, for example, and they work as a partnership, but they're not a limited liability partnership in that sense, so they would fall under this sole trader category. But if you're dealing with sole traders, they are not businesses and they are treated exactly as consumers. So everything that exists here, if you say, well, I work in a B2B environment and I'm only interested in working with businesses, well, if any of those businesses are sole traders, then you need to apply these consumer rules that I've just been going through. However, if you're targeting individuals within a business, then you don't actually need consent. So the regulation, so PECR, doesn't say you need consent, provided the marketing is relevant and you, again, must allow people the ability to opt out. You can market to businesses in a B2B context, provided they're not sole traders, without consent. So you don't need to worry about the GDPR consent compliant aspects. So this does mean that if you want to go to websites and scrape off business email addresses or find a load of chief executive officer email addresses or managing directors, and you want to send emails to them that are marketing emails, you don't need consent. You can actually do that, but you need to give them the ability to opt out. And if they opt out, then, as I was saying before with consumers, you can't do anything about that. That's it. They've opted out of marketing, and you must make sure that you have processes in place to make sure you don't send further marketing materials. If you're targeting generic business contacts, so you're targeting the accounts team at accounts@business.com, then that isn't personal data per se, but the marketing rules do say, again, you don't need to worry about consent, but the organization or an individual working within that accounts team, in my example, have the ability to opt out. And I think the complexity of the opt-out here in both those scenarios, whether you're targeting an individual or a business in a generic sense, is that you need to be clear whether somebody is opting themselves out as an employee or they're opting the business out. And so you would need to make sure you've got a good clarity about the way that you manage those opt-out processes. But you could argue, well, if you've targeted a managing director within a business and you've targeted the finance director in a business, but the finance director opts out, you can still market to the managing director, unless the finance director decides to speak on behalf of the business and say, don't contact our business ever again, in which case you need to make sure you've noted that difference in that individual as opposed to them choosing to opt the whole business out. So slightly more easier. Again, I think there's a brand awareness issue here in terms of expectations of individuals. This when I spoke to lots of people about GDPR and marketing data in the lead up to 25th of May, and this was one of the key questions that I got asked about, and people have actually quizzed about whether I'm telling the truth on this, because there is this perception that there is consent and you need consent to do any marketing. And there's a lot of people out there that think that GDPR has completely changed marketing data and that GDPR should therefore stop all marketing emails, even in a B2B scenario. That is not the case. Privacy regulations are very clear and straightforward on this. You do need to worry about consent if you're dealing with sole traders and consumers, but if you're doing B2B marketing, you don't need to worry about consent. But if you're dealing with people who have this perception that GDPR has fixed them not getting business-to-business marketing messages anymore, then expect the backlash of people saying, hang on a minute, where did you get my data from? Where's my consent? What was my permission? And I work with some businesses who have those kind of challenges, that they're acting strictly within the law, but there are business people out there who believe that consent changes in GDPR changed the fact that you need consent for the purposes of B2B marketing, which, as I say, and I'll say it again, you don't need to worry about consent when it comes to business marketing under the current privacy regulations. Now, as well as marketing and those other areas for telecoms providers, PECR and the privacy regulations apply to the use of cookies and similar technologies. So if you're using tracking pixels or other kinds of ways of interpreting or manipulating or storing data to help your users' experience or whatever, then that would probably fall under the similar technologies definition. But we tend to talk about cookies, and so I'll just talk about cookies from now on. So cookies, in case you don't know, are little bits of code which sit on a user's device, and they store sensible information about what somebody's viewed on the website. You typically would want to use them for on e-commerce websites, for example, for remembering what's in a basket when you're doing a shopping. So it would be annoying if you went to Amazon and you every time you bought something and it added it to the basket, next time you went to look for something, the bit that you just bought before wasn't in the basket anymore. And so that's all being remembered by cookies. Similarly, for logging in, the ability to log in and have access to your account and stuff within a website is all managed by cookie information. So they're little bits of information and data which are stored on a user's device, but they can be used for sort of nefarious illegal activities, and so there's controls around them. And basically, PECR says that if you're using cookies, you need to be upfront and tell people that you're using cookies. Hence why lots of websites have these cookie banners appearing on them when you first visit them. You have to explain what you're going to be using those for. So again, that's why these sites have information about a cookie notice or a cookie policy, or even reflected in their privacy statement about the cookies they're using and why they're using them. And strictly speaking, according to PECR, you also need to have the consent for the placing of those cookies on the user's device. So be upfront about the fact you've got cookies. So that's the openness and transparency that GDPR requires. Explain why you're using them. So that's the right to be informed again, which is what GDPR is all about as well. And you need to get consent for the use of cookies. Now, generally speaking, we tend to expect to get the cookie banner that pops up, and we expect to see some kind of statement saying we use cookies. You can read about them in our cookie notice. By using this site, you're confirming you're happy with continuing to use cookies. Otherwise, turn cookies off in your browser, or click OK to confirm that you understand this. That isn't strictly consent, and under GDPR, and certainly if you look at the Information Commissioner offices, so ico.org.uk, if you look at their website in terms of what they've done with their cookie notice, you'll notice that they're actually saying we use certain types of cookies, some of which you can choose to opt out of, and they provide the functionality for that. So in a post GDPR world, I'm afraid if you're using cookies, generally speaking, you need to probably look at what you're doing with your cookie notices, and the way that you're managing the interaction with cookies, and it's no longer acceptable to expect the user to turn cookies off in the browser. Now there are some exceptions to this, and if you look at the cookie section of the PECR website, the PECR part of the Information Commissioner's website, you look at the cookie bit, it will talk about some of these exemptions. So if you need to use cookies for the functionality of the website, so for example, if you're running an e-commerce website, it's all right to use cookies for maintaining the items in a basket, for example, then you just need to declare that that's what you use cookies for, and be clear that that's, that if people turn cookies off in their browser, then it will break that functionality. You can use those kind of cookies. You can also use non-essential cookies, so things like Google Analytics and other kinds of things for measuring activities where you're not actually collecting personal data, but you are recording information that's relevant to the use of a website, but it isn't essential for the functioning of the website. Now, strictly speaking, you should be seeking consent for those, but the ICO have sort of indicated that you can use those kind of cookies, but allow somebody to change their mind if they don't want to use them. The tricky bit will be finding a cookie mechanism that works for your website and for you, that enables you to actually provide that functionality of allowing somebody to opt out of those analytics cookies or non-essential cookies. Now, if you are collecting personal data, and particularly special category of data, so that's sensitive data, or you're tracking a user's behavior using those cookies, so if you're using pixels that determine advertising that might appear on other sites or on your site and things like that, then you will need to be clear that those is what you would like to use, and you would have to get specific consent. So somebody has to opt in to tick a box or however your cookie mechanism works to actually give you that consent. And I think again, the ICO have hinted that if you're placing analytics cookies on your website, and that's the only cookies you're using, then they're not that really going to be that bothered about investigating. But you must make sure you use a cookie notice and explain that you're using those kind of cookies, and tell people how they can turn them off in their browser if they want. But if you're storing personal data, and if you're collecting particularly special categories of data or sensitive data, or you're tracking behavior, then you can't place a cookie on a user's machine until they've given you specific consent. Again, I would say have a look at the ICO's cookie notice, and that will give you a good idea about how their pop-up, as well as their explanation about cookies, and that will give you a good idea about what sort of is the standard. Because, to be honest, if the ICO don't get it right, then there's no hope for any of us. So that was a quick rattle through ePrivacy as it stands today. So that's the privacy electronic communication regulations, and how that interacts with GDPR, particularly around consent and when you're doing marketing. But you may have also heard that there's ePrivacy regulations on the way. Well, actually, strictly speaking, these ePrivacy regulations were due to come in on the 25th of May of 2018, i.e. this year, at the same time as GDPR. But for one thing or another, not least of all, the road to GDPR was quite a long, drawn-out process. In terms of it being in the making, ePrivacy has not made that deadline, and it's still a draft regulation which is still being considered by the three pillars of European legislation and how that works in European law senses. There's a lot of speculation about when that might happen. Earlier this year, we were being told it's probably not going to be the 25th of May, but it'll be later in 2018. And then it started getting to be, well, it'd be unlikely in 2018. It's probably going to be the early part of 2019. And now there's noises being made that it may be delayed even further, because in 2019, there's a load of European elections that need to go with for MEPs and etc. And at that point, laws don't tend to get discussed and interfered with or debated or published until after the elections. And then there's a whole new routine of the new council and the regulation, the members of parliament and such coming together and deciding whether, under this next tendency of European governance, what laws need to go forward. So what I'm about to tell you is what we know as of today, which is not too dissimilar to what we knew probably a couple of years ago, to be honest, in the lead up to the privacy regulation supposedly coming on the 25th of May. It may happen sometime next year. It may not, or it may be delayed to later in the year. It really is difficult to say. But the new ePrivacy regulation is being referred to as such as ePrivacy regulation, although officially it has a very much longer name, and it repeals the underpinning directive that led to us having a privacy electronic communication regulations in the UK. Has these 5 areas that I'm just going to quickly go through in terms of the things that is likely to change, and some of them will be quite important, particularly based on what we've been saying so far. But being a European regulation, just as GDPR is a European regulation, it will be the law that applies across the whole of Europe. And the key areas that are changed is if you're a telecommunications provider or you're providing some form of telecommunications, and they're extending the scope of what that might mean to include things like Facebook Messenger, Snapchat, Instagram and the like, and other online messaging services, then you're likely to be captured by the requirements, particularly around better privacy communications of content and metadata. So that's information about things like, you know, when somebody connected for a call and the length of the call and the time and all those kind of things. They're likely to expand on who's covered by that, and also expand on better protections and better privacy for the use of those systems, and decreeing that, you know, that if you do go to this end-to-end communication system like Snapchat or WhatsApp, then you must have an encrypted connection and the like. When it comes to cookies, the good news is, because of all the confusion over the last 10-15 years about what a cookie notice should look like and how it works, they're changing this cookie control and consents process and actually putting the control back into the software. So the browsers that we all use are likely to have more granular options for controlling cookies, and there is likely to be very specific rules around what consents you need. Now, the good news is that it looks as though the consents will be that for essential cookies, the website won't work without them. Cookies, you wouldn't need consent. For analytics cookies, so if you use Google Analytics, provided your Google Analytics or your other analytics packages aren't tracking particular users, so if you're using things like HubSpot to be able to understand behaviors of visitors to your website, and that this person has contacted you on a form, which then means you can identify them on social media or that kind of thing, that wouldn't be covered by this. But analytics cookies that just simply measure how many people are visiting your website, what they looked at, that kind of thing, you're probably not going to need any form of consent for that. So that's kind of similar to where things are at the moment, but there will be very specific rules about the other type of consent. So a slight sea change in terms of what cookie controls may be in place, and a bit more power to the individual to determine what kind of cookies get used from a browser level rather than a per website level. Now, unfortunately, it's not particularly clear about what's going to change with regards to consent and direct marketing. At one point, it looked like it was going to be left to member states to determine what consents are needed for digital marketing technologies, and that means that it could very much stay the same as we've just been talking about earlier on with what exists with PECR. But at the moment, it's looking as though the regulation is likely to empower either the member states to implement the law, or be on the face of it itself, that you will need consent across the piece. So we could see a step change in the way that business-to-business marketing works with regards to consents. And I know that I've read some DMA articles that have sort of said, well, businesses aren't really asking for, you know, to have consent mechanisms like consumers in place for B2B marketing. But if you talk to a lot of the businesses, they are bothered by all the amount of spam and stuff they get. And this would be a way of trying to sort of curb that. So you do need to pay attention to this. I'm afraid there's no clear answer on this and what it might look like. And the next slide will explain also further complication. But there is a potential that everything I've just said about consents, particularly in B2B scenarios, could change, and we will need consent across the piece. No matter who you're marketing to, you would need consent unless you can rely on soft opt-in as an option because you've got a business relationship with them. And that might be the same for B2B as well as for consumers, which if you operate in Germany, you'll be familiar with anyway, because Germany's had that model in its own national law for some time. So the question is really whether this ePrivacy regulation is going down the same route as the laws and rules in Germany. And then the added thing, Hopefully we won't get all of the scaremongering we did with GDPR, but basically the regulation ups the level of fines to very similar to what they are in GDPR terms. So the uppermost fine could be 4% of global turnover or 20 million euros, whichever is the largest, as it is with GDPR. But I think as we have seen from GDPR and what the Information Commissioner put out, sort of dispelling these myths and rumours that we're all going to go out of business because we'll be fined 20 million euros if we get any little bit wrong, is unlikely to be the case. We will see hefty fines, and you just look at the ICO's website and the actions taken to see the kind of large fines that they're carrying out right now. But the privacy regulation updates the fine threshold to be the same as GDPR, not that we're likely to see such large fines as the maximum anyway. Now, the added complication is this is all very well and good, but in case you didn't realise or you hadn't spotted, we're supposedly leaving Europe next year in March, and there is some complications around what that might mean. So there's lots of complications about Brexit with regards to data flows, because from a data protection point of view, if you're processing data outside the EU, you need to make sure that the place where the data is being processed has got adequate data protection. That's why we have a Data Protection Act 2018 implementing GDPR. That's the UK's government's attempt to demonstrate that if we end up going down this route as being seen as a third country, like the US, like India, like countries outside of EU, then we can demonstrate we have implemented GDPR into UK law post-Brexit. Now, when it comes to the privacy regulations, there's a similar challenge in that it will depend what those privacy regulations mean in terms of implementation. If they don't get published and become law by the time we've Brexited, does that mean that the UK government will implement them as though they are in Europe? Will they implement them slightly differently? If the UK don't believe they need to regulate business-to-business marketing, does that mean the bits will be removed and so on? And could we be, if you target Europeans, then is there going to be a different set of rules depending on whether you're targeting UK or not? So if you've not had enough of Brexit and all the debates about whether we're going to be doing a hard or a soft Brexit, or whether we should or shouldn't be doing it, I'm afraid from a data point of view, be that data protection or indeed ePrivacy, then I'm afraid there's further discussion and further things to think about. Right, so that was pretty much what I wanted to cover. I've taken a little bit longer than I thought I would, and not helped by the technical problems at the beginning. So I won't labour on this too much, but just to tell you about my Digital Compliance Hub service. If you are worried about what you should and shouldn't be doing, if you need help and guidance, then the Digital Compliance Hub is something that can help you. It's a subscription-based service. You can try it for 14 days for free, and it's a mix of guidance, help and toolkits, as well as other things that can help you. But it also has a helpline, so you can book a call or have unlimited access to email support to get answers to your questions, particularly if they're if you've got some tricky areas that you want to try and interpret what the law means and how that applies practically within your business. And those three key areas there are the ones that I tend to look at with this service, although maybe in the future the scope might expand upon that. But that's data protection, particularly GDPR, privacy and marketing compliance, which is what we've just been talking about, and web and data and cyber security, looking at it from a very much a policy and process point of view, rather than I don't come out and fix the computers that have been affected by ransomware and things like that. You have to get an IT specialist in to do that. So that's something for you to consider. And I mean, this talk is one of a number of webinars I'm running, hopefully on a regular basis, and the next one is coming up. In fact, I've got the slides around the wrong way. And the next one is coming up actually, I'm not sure it is September the 26th. I have to check the date on that. But there's if you go to the Digital Compliance Hub website, digitalcompliancehub.co.uk, click on events, you'll see when the next webinar is, and it's dealing with subject access requests. So if you're interested in GDPR and how to deal with subject access requests, that's what that webinar is about. But that was all I wanted to cover, and I hope you found that useful. There's 10 minutes or so free for answering questions, and I've got a few things on my display here. So let me have a look and see what we've got. Okay, so somebody was just asking, and apologies for rambling on for the 40 minutes and not responding to your question, because I could have probably answered it as we went through. Asking to clarify, is this all about PECR and GDPR, or is this about the Data Protection Act as well? Well, the Data Protection Act 2018, which came into play on the 25th of May, the same time as GDPR, essentially enforces GDPR. It does have some exceptions or exemptions to some of the processing where the GDPR allows it, but for all intents and purposes, the Data Protection Act is our UK implementation of GDPR. If there's anything in the Data Protection Act 2018 which doesn't meet the requirements of GDPR, whilst we're still in Europe, GDPR would gazump it essentially. So yeah, so in answer to that question, I'm talking about data protection as it applies in the UK, which is the Data Protection Act 2018, which implements the GDPR. So GDPR, Data Protection Act 2018, whichever which way you want to refer to it, the data protection legislation in the UK, and it's about PECR. Okay, I've got another question. Under PECR, where consent is not required for targeting individuals within a business with digital marketing, does this still apply if the email address you have has basically got a name in it? Well, actually, that's targeting an individual. So if you're targeting fred.blogs@business.com, that is his personal data, and you would need to apply data protection to how you're processing that. But the privacy rules say you can do that without consent as long as you adhere to any opt-outs that might be sent your way. So yes, the requirement to get consent applies to a business-to-business communication, even if the email address you have for the individual targeting includes their name. You just need to be mindful that that kind of targeting and having that personal data, you're processing personal data, so other elements of data protection apply, and data protection says your processing must be lawful, and PECR says it is lawful in the sense that you don't need to have consent. So I hope that answers that question. So great question from Maisie, saying, if a person, a consumer or business has opted out, can we contact them to ask why? Well, you could claim under data protection that you have a legitimate interest to ask those kind of questions, but you need to be very careful. So I think within the context of somebody opting out, you could say, we've seen you opted out, we're sorry to see you go, can you give us a clue as to why you're opting out? And you know, some of the email marketing platforms allow you to sort of do those follow-up questions whilst you're unsubscribing. Then I think that would be reasonable, but you would have to be able to demonstrate that that's a legitimate thing to do and that you're not marketing in the same way. So if you were saying, you know, why, you know, choose one of these 5 reasons why you might be opting out, and we're sorry to see you go, but you know, just to while we've still got your attention, don't forget we can sell you this service or these products, then I think you might be stepping across the line. But I think it would be a legitimate interest for you to follow up and ask, but you need to be very careful that that is not construed as marketing. But make it as simple as possible, and if you can, automate it where you can. Hope that makes sense. And okay, so I think that's exhausted the questions. I made reference to PIP earlier, and apologies for not explaining that acronym if you're not familiar. I think I meant PPI actually when I think of PIP. I meant PPI. So when I was talking about some changes to the PECR rules in the last week or so, because the government have enforced or empowered the ICO to fine businesses who don't have consent of any kind to anybody to sell personal, I think is it personal protection insurance? PPI, it's a form of insurance that we've all been allegedly missold, and we were all bombarded by cold calls trying to help us with that. So apologies for the confusion with the PIP and the PPI. I was getting my acronyms mixed up and then not explain them as well. Okay, so Elena is asking an interesting question about. I mentioned the German model for data privacy, which basically requires consent for everything, regardless of whether you're dealing with targeting businesses or not. About whether there's a central place where you can gain business-to-business data protection policies from all European countries. As far as I know, I think the answer to that is that there isn't. Obviously, GDPR applies across the whole of the EU. Unfortunately, the ePrivacy, as we see it, so our privacy and electronic communication regulations, is the UK's interpretation of the previous ePrivacy directive. And it being a directive means with a few things which are sort of forced upon member states. In European law, directives can be implemented or interpreted as they want by the member state. Where a regulation, which is why GDPR has had such a wide impact across the world, not just Europe, being a regulation, and this new ePrivacy regulation coming means that it basically replaces all member state laws in that applicable area and applies. That said, different member states, as we have implemented Data Protection Act 2018, have implemented their own regulations and laws that essentially enforce GDPR into their member state law and perhaps repeal previous regulations. And I think I saw this week that Belgium, for example, have just published their law, but I'm not aware of a central depository of European member state laws in this particular area. But thank you for asking that question, and actually maybe it's something that is a function or facility of the Digital Compliance Hub that might be useful if people would find that of some use. There may be some resources out there that give you those kind of pointers, and there are I'm sure other providers that might be able to give you that. Lawyers probably have a depository they have access to, but I'm not generally aware of a publicly available one. Okay, well, thank you for those who have sent me a message to say thank you. That's very kind, and I hope that was useful. We're pretty much at 1 o'clock, so unless anybody's got any last-minute questions to ask, I'm happy to leave it at that. As I said, I've recorded the session, so what I'll do is I'll upload a recording and copy the slides for you to download in case they're helpful, and I'll send you a link to that when at some point in the near future. Yeah, hope that was really helpful. Thank you very much for joining. If you are interested in the subject access requests webinar that's coming up next, apologies for confusions about dates. You'd think I'd know when my next ones are, but I've got quite a few different ones running at the moment. So I'm just going to quickly look when I get a second, and I'll update the slide pack I put online to make sure that reflects the same date. But have a look at Digital Compliance Hub. If you're interested in finding out about GDPR and what it means for subject access requests, then hopefully you'll sign up for that, and I'll speak to you again soon. Great. Okay. All right. Thanks very much. Enjoy the rest of your day, and hopefully speak to you on another webinar one day in the future.